Welcome to the deep dive. Today we're jumping into a really interesting U.S. Supreme Court ruling. It's called Catholic Charities Bureau, Inc. v. Wisconsin Labor and Industry Review Commission. Yeah, and the sources we've got lay out this kind of classic legal puzzle. At its heart, it's about religious freedom, sure, and tax exemptions. But the twist is, well, it's pretty unique. We're looking at a situation where a state denied a religious group a tax break, almost because they were too charitable, in a way that actually went against their own faith's teachings.
That's a great way to put it. So for you listening, our goal here, our mission in this deep dive is really to unpack the legal side. How did Wisconsin Supreme Court read their own state law in a way that the U.S. Supreme Court said, nope, that violates the First Amendment?
Yeah.
We're specifically talking about the idea that the government has to be neutral between different religions. And when a state crosses that line, it brings out the big legal guns, strict scrutiny.
Right. And what makes this dive really interesting is, okay, the Supreme Court's decision was unanimous. They overturned the state court. But, get this, there are 3 separate opinions. So we have a clear answer on this specific case, but there's clearly some deeper debate going on about what this all means down the road. We'll unpack the facts, the conflict, the constitutional problem, and then really zoom in on those concurrences and the nuances they raise.
Okay, let's start with the basics. Wisconsin has an unemployment system, like pretty much every state. Most employers pay payroll taxes into a fund. And that fund, it's there to help people out, give them some income support if they lose their job for reasons that weren't their fault. Simple enough.
Standard stuff.
But there's an exemption for certain religious nonprofits. Now, the state law, and it pretty much copies the federal law, FUTA, you might have heard of it, the Federal Unemployment Tax Act. It says a nonprofit gets this tax break only if it meets 2 conditions. First, it has to be, quote, operated, supervised, controlled, or principally supported by a church. And second, it must be operated primarily for religious purposes. 2 distinct tests.
Got it. And who are we talking about here? The groups involved, the petitioners?
Yeah, this isn't some tiny operation. It's Catholic Charities Bureau, Inc., and some related groups. They're basically the social outreach arm of the Roman Catholic Diocese of Superior.
And they do important work, right? Like Black River Industries, Barron County Development Services. They help people with disabilities find jobs, get involved in the community. These sound like, really vital local services.
Absolutely essential community organizations. So that first test being controlled by a church, easy check mark. The diocese clearly controls them. But the state tripped them up on the second one. They said Catholic Charities was not operated primarily for religious purposes.
Okay, and this is where it gets, frankly, a bit weird. It stops being just about tax law and starts getting into theology.
Yeah.
Tell us why the state denied them on that second point.
Well, the denial came down to a really specific judgment about how they practice their religion. The Wisconsin court basically said, look, Catholic Charities doesn't qualify because, 1, they don't proselytize.
Meaning they don't actively try to convert the people they help.
Exactly. They don't try to push Catholic beliefs onto the people they serve. And second, they didn't limit their services just to Catholics. They helped everybody, regardless of race, sex, religion, whatever.
Wait, so they're being penalized for not trying to convert people and for helping everyone.
That sounds backwards. It does sound backwards. And the charities themselves pointed this out. They said, look, our choice not to proselytize when we're doing charity work, that is a religious decision. It's based on actual Catholic teaching that warns against, and this is their phrase, misusing works of charity for purposes of proselytism.
Wow. So they follow their faith's guidance on charity, and the state essentially says, sorry, that's the wrong kind of religion for this tax exemption.
Precisely. The state basically set itself up as judge of what counts as religious enough for the tax break.
Which, as you said, immediately makes you think First Amendment violation. You can't have the government playing theologian.
You really can't. And Justice Sotomayor, writing for a unanimous court, was very clear on this. The First Amendment demands denominational neutrality. The government just cannot play favorites between different religious views or different ways of practicing faith. If a state law deliberately distinguishes between religions based on their core practices or beliefs, it automatically faces strict scrutiny, no messing around.
So, the Wisconsin court saying you need to proselytize, or you need to limit services only to your own members, that was labeled textbook denominational discrimination. The state was basically picking a winner, favoring an evangelizing style of charity over a service-focused one.
That's exactly the court's point. Whether Catholic charities qualified or not turned on these inherently religious choices. It wasn't about some neutral administrative rule, it was about the content of their religious beliefs and practices.
Can you give us an analogy, something to help make this denominational discrimination idea really click for folks listening?
Sure. Think about it like this. Okay. Imagine a state has a property tax exemption for churches. But the law says you only get the exemption if your church performs baptisms.
Oh, okay.
Or maybe the law says the exemption only goes to religious groups that hold their main worship service on a Sunday.
Right, that clearly favors certain Christian denominations over others, like maybe Jewish or Seventh-day Adventist groups.
Exactly. Those laws are drawing lines based on specific rituals or practices. They're favoring one set of religious doctrines. The court said Wisconsin's rule here was doing the same thing, just focused on whether you proselytize or not. It's picking a preferred way to be religious.
Okay, so because it was discrimination, strict scrutiny gets triggered. And under strict scrutiny, Wisconsin, the state, has this huge burden. They have to prove the rule was narrowly tailored to achieve a compelling governmental interest. That's like the highest legal hurdle there is.
It really is. And, well, this is where Wisconsin's whole case just crumbled. They couldn't prove that narrow tailoring. They tried to argue two main interests. First, the big one, ensuring unemployment coverage for its citizens.
That definitely sounds compelling. I mean, states need to ensure that safety net, so why didn't that argument fly?
Because the way the law was applied here was under-inclusive. It didn't actually fit that goal very well. The court pointed out a couple of big problems. First, like we mentioned, these Catholic Charities groups. They already had their own system, basically equivalent to state unemployment insurance, for their employees. So denying them the state exemption didn't actually make their employees any more secure.
Okay. So it didn't really advance the goal in their case.
Right. And second, and this was a huge flaw, Wisconsin already gives an exemption to the main church, the diocese itself, under a different part of the same law.
Hold on. So the diocese, the church structure, could run, say, a food pantry or job program itself without proselytizing, and it would get the tax exemption.
Yes.
But if it sets up Catholic Charities, a separate nonprofit entity to do the exact same work in the exact same way, that entity gets denied.
That's precisely the contradiction the court jumped on. If the state's real interest, its compelling interest, is making sure as many people as possible have unemployment coverage, why exempt the church doing charity, but not the church's charity arm doing the same thing? That inconsistency, the court said, it just belies the state's claim of narrow tailoring. It showed the state wasn't really laser-focused on maximizing coverage. It was drawing this odd line based on, well, seemingly religious structure or practice.
Makes sense. Okay, what was their second argument? You said there were two interests.
The second one was about avoiding government entanglement with religion, specifically with religious employment decisions.
Ah, the idea that the state doesn't want to get caught in the middle of disputes about, say, whether an employee who was fired violated some religious doctrine.
Exactly. That's a valid concern rooted in the First Amendment, too, keeping government out of internal religious affairs. But here, the court said the law failed because it was over-inclusive.
Over-inclusive, how so?
Well, the state argued that entanglement could happen if they had to judge misconduct cases involving employees whose job it is to, teach the faith, inculcate religious values. But the problem is the tax exemption itself, the way Wisconsin wrote it, applies to the entire organization, every single employee. It covers the priest, sure, but also the janitor, the cook, the office administrator, everyone.
I see. So the state's worry is about entanglement regarding, say, a religion teacher's firing.
Right.
But the law exempts the whole organization, including the groundskeeper, who likely has zero role in teaching religion.
Precisely. If the state's genuine concern was only about those potential disputes involving employees with religious teaching roles, the law should have been much more targeted, maybe focusing just on those specific jobs. But by making the exemption apply organization-wide, covering everyone equally, the law was just too broad, too clumsy. It swept up way more than necessary to address that specific entanglement concern. Poor fit. So again, it failed the narrow tailoring part of strict scrutiny.
So the unanimous decision strikes down Wisconsin's application of the law. Pretty clear-cut on the outcome. But as you mentioned, this is where things get really interesting for the future, with those concurring opinions.
Yeah, it's fascinating. You get this 9-0 result, but underneath, there are these quite different legal perspectives bubbling up. The majority kind of stuck to the narrow issue of denominational discrimination, but the concurrences wanted to say more.
Let's start with Justice Thomas. His concurrence focused on something called the church autonomy doctrine, right?
That's right. Thomas agreed with the result Wisconsin loses, but he thought the Wisconsin court went wrong way earlier in the process. He argued they shouldn't have treated Catholic Charities and its subgroups as just separate corporate entities, legally distinct from the diocese itself.
So he's basically saying the state can't just look at the incorporation papers, the secular legal structure, and ignore how the church itself defines its organization.
Exactly. The church autonomy doctrine basically says religious institutions have a First Amendment right to decide their own internal structure, their own governance, who counts as part of their ministry, without the government stepping in and second-guessing them based on secular legal forms. Since the diocese clearly considers Catholic Charities its social ministry arm, and the diocese itself would qualify for the exemption if it did the work directly, Thomas says the state can't use corporate law technicalities to slice and dice the church's structure just to deny a tax benefit. It's an internal church matter.
That resonates with the whole separation of church and state idea. The state shouldn't be drawing organizational charts for religious bodies. Okay, then we have Justice Jackson's concurrence, which takes a totally different approach, focusing on the words of the law itself.
Yeah, Justice Jackson drills down into the statute, both the Wisconsin version and the federal feudal law it copies. She zooms in on that key phrase, operated primarily for religious purposes. Her argument is that we should interpret that phrase based on the organization's function, like what does it actually do day to day, rather than its motivation, why does it do it, what are its religious reasons.
Function versus motivation. Why is that distinction so important? I mean, if a church runs a soup kitchen because their faith tells them to feed the hungry, isn't the motivation religious?
It absolutely is. But Justice Jackson argues, looking back at the history when FUTA was passed, that Congress didn't intend for every church-run entity to be exempt just because it has a religious motivation. She points to examples from the legislative record. Congress seemed to intend the exemption for entities doing core ministerial functions. Think seminaries, training priests or ministers, or maybe novitiates where people are preparing for religious orders.
Okay, things directly related to the clergy or religious life itself.
Right. But, she argues, Congress explicitly seemed to indicate they did not intend to exempt general charitable organizations like orphanages, hospitals, retirement homes, even if they're run by a church and driven by strong religious conviction.
So, under her view, if the organization is basically doing a job that a secular charity could also do, like running a disability employment service or a hospital, then even if it's run by a church for religious reasons, it might not qualify as being operated primarily for religious purposes based on its function.
That seems to be her point. And her reasoning ties back to that entanglement issue we discussed. She suggests that focusing on function helps avoid entanglement better. Why? Because labor disputes involving, say, a cook or a janitor at a church-run hospital are usually less likely to involve complex religious doctrine than disputes involving a minister or someone whose specific job is teaching the faith. So limiting the exemption to core ministerial functions might reduce those tricky entanglement problems for the government.
That's a really significant alternative way of looking at the whole exemption scheme. Okay, let's pull back and wrap this up for the listener. What's the big takeaway here from this unanimous but clearly complex ruling?
Well, the absolute core finding is clear. The Supreme Court said Wisconsin messed up. The state applied its tax law in a way that forced Catholic Charities to choose between different parts of its own religious beliefs, its mission to serve everyone, versus its doctrine against proselytizing and charity. And the fundamental rule is the government can't use its tax power to reward one kind of religious practice and penalize another. That's the denominational discrimination that triggered strict scrutiny and led to the reversal.
Right. The discrimination was the fatal flaw. But the really big question left hanging, the thing for you to think about, comes directly from Justice Jackson's concurrence, doesn't it?
It really does. If courts in the future start leaning towards Jackson's functional interpretation, if they start saying that general charities, even deeply religious ones, aren't primarily for religious purposes just because they provide secular-type services, well, that could rewrite the rules entirely. Think about it. Dozens of states have laws similar to Wisconsin's, often granting broad exemptions based mainly on the fact that an organization is church-controlled. If the focus shifts from who runs it and why to what it actually does, what happens then? That functional versus motivational debate. That could be the next major legal battleground for religious exemptions in employment law across the U.S. Lots to watch there.